Okay, we ask everybody, welcome to the Alliance of Angels next educational seminar. We're proud to have K&L Gates who's one of the AOA sponsors, be willing to give us this seminar on the importance of intellectual property. But as is our habit when we start, I'd like to tell you a little bit about the Alliance of Angels. We are dedicated to funding Northwest startups. We are the largest and most active angel group in the Pacific Northwest. And we like to think that we are at the center of the startup funding in our region. We're not just the largest group with over 140 active members, but our member mix is a group of angel investors, including many super angels, prominent family offices and local PCs. And we're proud that we're also the #1 funder of female-led startups in the Pacific Northwest. In order to achieve this, we have to fund the most deals. We invest in over 20 deals per year with a total investment of over 10 million, and we've done that for quite a few years running, more than any other angel group in the region. 40% of the companies presenting at the Alliance of Angels meeting every month get funded. The average amount we invest per deal is quite variable, but typically ranges between $250,000 to $500,000 per deal. We've had deals as high as 5 million and deals as low as much smaller if that's all they're raising. Our members invest in startups across a wide range of sectors. We're not sector specific, and that also makes us somewhat unique. Having AOA investors in your deal builds credibility for future fundraising. We estimate that for every dollar an AOA investor puts into a deal, we get between 2 and 3 times as much from other investors in the region and nationally. A number of area angel groups attend the AOA meetings so they can spot good startups and bring them to their groups. And 80% of the entrepreneurs who received AOA funding successfully have completed the round. But we're also proud of the fact that we can help with more than just money. AOA members have deep business experience in a wide range of sectors and disciplines. Many members are currently entrepreneurs or have been in the past, and they can provide invaluable business advice, contacts, connections, references for hiring good people, and then also help with future rounds of financing. So that's the AOA story. And at this point, I'd once again ask people to please mute while Pam and you are speaking, and we'll allow time for questions at the end. If you haven't muted yourself, I may mute you out of courtesy to the speakers. So with that, let me turn it over to you and Pam to introduce themselves and get the talk going.
Thanks, Dan. Hi, my name's Hugh Matsubayashi, and I've been practicing as a patent attorney for over 20 years. I'm currently a partner at K&L Gates here in Seattle, where I assist with the patent portfolio development for companies large and small, as well as providing IP counseling for various transactions and investments. I'll pass it over to my partner, Pam. She can give you a quick intro of herself as well. Oh, I think you're muted there, Pam.
Can you hear me now?
Yep.
Good morning, everyone, and thank you, Hugh. As you said, my name is Pam Jacobson, and I'm a partner out of the Seattle office of K&L Gates. I also serve as the firm's firm-wide practice group coordinator for intellectual property. And like Hugh, I'm a patent attorney by training. I worked in AI research at the University of Chicago and at Allied Signal, now Honeywell, before law school. My practice is fairly broad and covers the gamut of IP from patents to trade secrets, trademarks, copyright, and related litigation. And I'm looking forward to talking to you after Hugh's presentation on patents on those other forms of intellectual property.
All right, thanks, Pam. So let me go quickly through our agenda for this presentation. We'll start with sort of IP basics. I'll start with describing patents and the various types of patents there are. Then Pam will cover trade secrets, trademarks, and copyrights. Then we'll wrap up with some best practice tips. And so thanks for all going on mute, but please, as we go through this, feel free to unmute and jump in with questions, or if you want, you can just throw it into the chat, and hopefully I will be able to see that, and we'll try to pause periodically to answer your questions. So, IP basics. So under the law, there are three forms of property. There's real property, which is sort of what we consider as real estate, buildings, and that sort of thing. There's personal property, which is all the physical stuff there is in the world that isn't real estate. And then there is intellectual property, which are creations of the mind. And so IP is just a general term for these various categories of intangible creations. There are four main types of IP. Patents protect useful inventions and discoveries. Trade secrets protect valuable confidential information. Trademarks protect products and company identifiers. And copyright protects expressions of art, music, dance, etc. So starting with patents, there are a lot of misconceptions about patents. So what a patent is it's an exclusive right to prevent others from making, using, selling, or importing your invention. And a patent only applies to a single country and for a limited period of time. What a patent is not is it doesn't give you an affirmative right to practice your invention. And an example to illustrate this is, say you patent a diesel-powered smartphone. And so in this case, you would have the right to sue anyone else who tries to sell diesel-powered smartphones. However, if someone owned the original patent on the diesel engine, they can still sue you for infringement because your diesel-powered smartphone infringes. Another thing that a patent is not is that it is not indestructible. So there is a multi-year process to first get your patent from the patent office, but even once it issues, it can still be later invalidated by a court or by the patent office. So you could lose that right. Now, there are different categories of patent applications. I'll go through each of them now. So design patents. So design patent protects the appearance of an item. So it protects the aesthetic appearance. It does not protect the functionality. And so on the screen now are a couple of examples of design patents. And so again, it doesn't protect any of the functionality in the Beetle or in the sunglasses. That's really if anyone sells a product that looks confusingly similar to that product that you patented. Then a couple of distinctions is that the design patent applications are good for 14 years from issuance, after which point the invention is dedicated to the public. And if you want to foreign file, so file counterpart applications in foreign countries, you must do so within 6 months of your earliest filing. Then there's something called the provisional patent application. This is one that it establishes a filing date for your invention. Quite a few startups there's some misunderstandings about what provisional patent applications do. They do not provide any enforceable rights. It really just is a placeholder that gives you the right to then file a non-provisional or foreign counterpart within 1 year. These provisionals are kept secret by the patent office until the non-provisional counterpart issues or publishes. One mistake that a lot of startups make is that the patent office doesn't examine provisional patent applications. It really just kind of goes through a basic formality examination and then is stored in the database with a timestamp. And so many startups will file really skimpy disclosures, even a PowerPoint slide deck, and they'll file it with the patent office and then think they're fine, think they're safe. But the fact is that provisional applications, the disclosure requirements, the requirements for how much information needs to be contained in the application, it's actually the same as for non-provisional applications. And so when you file something like a PowerPoint deck, there is a good chance that that provisional application doesn't get you anything. There isn't enough detail to support the patent, in which case that provisional filing date does nothing. You can still label, once you file the provisional, you can still label your product with patent pending, but that really doesn't give you any enforceable rights. It's just kind of a deterrent to would-be competitors to let them know that you have a patent coming, and so to deter them from copying your invention. Now, the next are non-provisional utility patent applications, and this is what people typically think of when they think of patents. And this protects any sort of device or method of operating or making devices. They're good for 20 years from when you file them. Like provisionals, they're kept secret by the PTO until they publish or issue. And again, there are no enforceable rights until the patent actually issues. There is a category of plant patents, and this protects certain varieties of plants. I don't practice in this area. I guess my one piece of advice would be to make sure that you work with a patent attorney who handles plant patents regularly, because they are quite different than other forms of patent. So finally, foreign patents. And as I said earlier, patents are country specific. So if you get a patent in the US, you're only protected for activity within the US. So if you want to have protection in other countries, you must file foreign counterparts to your US application. And there are treaties that enable you to file the foreign counterpart within 1 year of your US filing date, and you get the same benefit of that earlier US filing date. There is not anything sort of akin to a worldwide patent. For most countries, they are country specific. There is something called the PCT, which is a treaty among most major countries, and if you file a single PCT application, there is a centralized examination, and then 30 months after your earliest filing date, you then need to select which particular countries you want to pursue. There are also some regional patent applications, but as a general matter, you will ultimately need to get a patent in each individual country, and that can be quite expensive. You know, what sorts of things can be patented? And in the past, the Patent Office was very loose in what they permitted you to patent. The language in one decision was anything under the sun that is made by man. But more recently, there's been considerable narrowing of the scope of what's considered patentable subject matter, and especially when it comes to software and life sciences diagnostics. Some examples of things that cannot be patented are sort of abstract ideas, natural phenomena. You can patent applications utilizing these abstract ideas, but you can't patent the underlying idea itself. So the next slide is directed more to software. The idea mainly is that you want to patent improvements. So anything that makes the computer perform better is something that's likely to be patentable. If you're just taking a known process and computerizing it, putting it on the web, that's generally the sort of thing that isn't going to be allowed by the Patent Office.
Hugh, before you move on from that, there are a couple questions in the chat that you may want to get to.
Yeah, thank you for.
Does provisional or non-provisional patents include the design patent also?
So provisionals do not, you can file a design patent from a non-provisional. So there are things called the continuation. So once you file a patent application, you have a set of claims at the end that sort of define what you believe to be in your invention. You can then file continuations, which are basically photocopies of your patent application to pursue different aspects. So it's a little complicated, but I guess the short answer is not really. They are distinct forms of patents. There's some ways to kind of get around that and use one type of patent application as priority for the other, but they are distinct. Let's see, can you label non-provisional patents patent pending in selecting countries in October? I'm not sure I understand that entirely. So you can, once you file the non-provisional patent application, you can mark it with patent pending. There's no cost to marking it that way. And in fact, there really isn't any legal benefit to marking it patent pending. It's really more a marketing effort. So is it to the cost of filing? So I think you're asking, is there an additional cost in selecting countries in the PCT application? And okay, great. So when you initially file the PCT application, no, there's one single filing fee and it covers all of the countries that are part of the PCT. However, when you get to the 30-month deadline, that's when you need to select which individual countries you want to pursue. And at that point, you do need to pay the filing fee for each country, as well as often filing translations and getting hiring patent attorneys in each of those countries to handle those patent applications. So it is a very expensive process. Typically, companies don't file broadly unless there's some really compelling reason for it. Especially in the electronic software space, the US is really the focus. Sometimes they'll file in China or Europe, but really the only patents that are filed really broadly worldwide are ones really high value products that derive their value from the patents, and that's usually pharmaceuticals, biotechnology. And those are really the only ones where you would normally file more than a handful of different countries. All right, unless there are any other questions, I'll pass it over to Pam and trade secrets.
Thanks, Hugh. So Hugh talked a bit about patents, and as he said, you're awarded this 20-year monopoly on an invention, and you're given that in exchange for disclosing that invention to the public. So what happens if your invention isn't entitled to patent protection? Or what if you want to have a longer term monopoly and the invention, you can't readily ascertain the invention from the product itself? And I think this is where trade secret law comes in. So what is a trade secret? So let's take a look at this slide. A trade secret is information that people don't generally know and that gives a company competitive or an economic advantage. And most importantly, it's something that's the subject of reasonable security efforts. So trade secrets can include computer code, product specification, customer lists, and I think we all know the famous list of trade secrets that include Coca-Cola's recipe, Google search algorithm, and finally how the New York Times arrives at its bestseller list. So next slide, please. Let's talk a little bit about the benefits of trade secret protection versus patents. So, and there are several that are considerable. First of all, trade secret protection can last indefinitely, whereas, as Hugh said, patents extend only for 20 years. That monopoly only extends for 20 years. There are no registration costs or costs associated with formalities for trade secrets. There are internal costs, but no registration costs, as there would be for filing a patent application and prosecuting in the United States and throughout the world. The breadth of protection for trade secrets is far broader, whereas in patents you need to meet certain statutory requirements to obtain a patent. And finally, there's the timing issue. You can defend your trade secret and protect it almost immediately, whereas for a patent you need to apply, you need to go through prosecution with the USPTO and abroad. So what do you need to own a trade secret? Next slide, please. So you need to protect it. So one of our clients, Zillow, was recently involved in multiple trade secret disputes and against a competitor. And we went into the litigation knowing that there were adequate protections in place. So this is just a crucial aspect of trade secret protection. So what specifically does this mean? It means you've identified your trade secret and you understand what the metes and bounds of that trade secret is. 2, you've also taken reasonable measures to keep the information secure, like physical restrictions for like the Coca-Cola recipe or to any information in terms of electronic information by somehow imposing limitations on the access of trade secret electronic information. You've also kept your employees secure. So you've made them sign an employment agreement. There's an employee handbook. You've made them sign a non-disclosure agreement. You've implemented security protocols during the course of their employment. You give them an exit interview and make them sign an agreement where they acknowledge your trade secret. So you take these reasonable steps to ensure the confidentiality of this information. Finally, if you've seen that your protectable trade secret is being violated, you enforce it against that third party. And there are a lot of immediate steps you can take internally with trade secret protection, as you can see, as a company without filing for registration. Next slide, please. So now let's turn to trademarks. And the reason why trademarks are, I think, one of the most important forms of intellectual property is because they are largely the most valuable intangible asset a company can own. It's relatively inexpensive to acquire. It can last, trademarks can last forever, and it is worth the most. So the Google trademark is worth $45 billion. The Microsoft trademark is worth over $42 billion, and Walmart trademarks are worth over $32 billion with a market cap of $184 billion. So a lot. And so let's talk about trademarks briefly in greater detail. The next slide, please. What are they? So a trademark is essentially a brand. It's a corporate brand, and we know them. They're like Coca-Cola and Haagen-Dazs. They can be words, they can be phrases, symbols, and designs. And they can also be non-traditional elements like colors, such as a red color at the bottom of a shoe. So they can take any form, any of these forms, so long as consumers associate that mark with the source of a product. Next slide, please. And trademark rights are also fairly inexpensive to acquire. You can acquire common law rights through use, and you can also acquire rights through registration. As you might expect, registration confers a significantly broader scope of protections and benefits, such as, for example, nationwide use is presumed, and your rights can become incontestable after using marks for 5 years. Next slide, please. And one of the most crucial ways to protect your trademark rights or your brand is that you need to use that brand or those marks properly. And there's really only one way to use that as, you can use a trademark as an adjective modifying a noun, such as a Band-Aid brand, Band-Aid. And you also need to police third-party uses of confusingly similar marks. So if you own a trademark registration and third parties are infringing on that use, if you allow that use to continue unabated, you will lose your trademark rights. So you at a minimum need to send a cease and desist letter or find a way where it's not confusingly similar and you have a record of your attempts to enforce it. Next slide, please. So finally, we're going to briefly talk about copyright protection. Next slide, please. So copyright protects original works of authorship, as Hugh mentioned in his original slide, but original works of authorship that are fixed on a tangible medium of expression. So what does that mean? So an outdoor performance isn't a protectable copyright, but a recording of it that recording of the music fixed on, as a recording, as a tangible medium of expression, that is protectable under copyright law. And I thought I'd briefly point out the biggest issue with copyrights for startups. The first is that they don't seek copyright protection within the first 3 months of publication. It's a $35 application fee, and it confirms, filing it within that 3-month period allows you to sue someone else and obtain statutory damages. And that is a huge deal. It's a huge cost savings in litigation. The second issue is that startups don't properly keep track and record ownership of copyrights. And I think this is true for all of IP. So it's important to remember, it's just like real property, just like owning a home. You buy it, but you also need to record your ownership after acquisition. And this gives third parties on notice that you own the right and allows you to recover damages in the future. So of course, if you guys have any questions, please let me know. You can feel free to email me directly or ask them now. I'll turn it back to Hugh to talk about IP best practices. Thank you.
All right, so unless there are questions, we'll wrap it up with just some tips on IP strategy. So when a company develops its IP strategy, there are different objectives that they might want to consider. One is an offensive strategy to block competitors from releasing products that infringe your patent. There's a defensive strategy where you compete in the marketplace just based on your products, and you only rely on your patents in the event that you're sued or approached for licensing, and you can assert them back. Another is revenue. So many companies, especially large companies, have licensing programs where they'll actively go out to competitors and offer to license their patents. There are some companies where that is the entirety of what they do. They're sometimes referred to as patent trolls. They'll acquire a portfolio of patents and then go out and assert them against companies that are selling products. Another objective is fundraising. So when you're going out and looking for investors, having a strong IP position increases the value of the company, and also offers licensing opportunities to strategic investors. And the final is sort of a strong exit to your startup. Having a patent portfolio can really increase the value to an investor. And I see a question here. So how can angel investors check on the quality of patents during the due diligence process? What questions to ask, what docs to review? So it is tricky. In some cases, investors will hire their own patent counsel to review the patents. That is, it's an expensive proposition, and so it usually isn't worth it unless the investment is significant or if the patent is really core to the value of the company. So, the example of a pharmaceutical, having a strong patent is sort of critical to the success of that company. So it is worth hiring a patent attorney to review the patent closely. Sort of the other end, you can just conduct a basic diligence where you ask the target company about their IP practices. You can do a check to ensure that the proper assignments are recorded, so that the ownership of the IP is established, and sort of inquire generally about whether that company is following IP best practices. The tricky thing for many startups is that patent applications are very expensive to file. So in many cases, they just don't have the capital to spend. So I think the important thing for investors is to make sure that the company has thought through their IP strategy. So if they don't have any patent applications, that they can articulate a reason why they don't have any, and a plan going forward, how they intend to protect the IP going forward. These are all things that sort of at a high level, your corporate counsel can assist you with this, and then they can often bring in a patent attorney to dig in deeper if it's needed. Let's see, going back to the slide. So some strategies, as Pam mentioned, trade secrets. You know, some companies will rely on trade secrets for protection because it doesn't have any cost and the protection is immediate. Some companies will file only on their core ideas, so they may file only 1 or 2 patent applications covering the core concept for the company. More mature companies or those with better funding have the money to file patents on secondary features, on various implementations, and you know, broaden the protection in that way. And then companies will sort of consider strategic foreign filing, whether if any foreign filing makes sense, and if so, which countries to pursue.
So if as an angel investor, if we really wanted to get a sense of this, how much should we budget for an IP review of a patent? Order of magnitude.
That's a good question. So if it's a single patent application, excuse me, you know, sort of ownership review, so review of the patent assignment database, you know, it's on the order of thousands for, I guess, hundreds per patent. It's not very expensive. To dig into the details of a patent application, that can be very expensive. You know, it depends on how complex the patent is. If it's a very simple patent, you know, it could be in the order of a couple of thousand, I think. But if it's a very complex patent with a long prosecution history before the patent office, it could be many thousands. There's also something called the freedom to operate, which maybe I'll jump back to my slide here. When these companies execute on their IP strategy, they want to make sure they file their patent applications early. And another mistake that many companies make is that they don't align their patent efforts with their business strategy. You know, startups often change focus, they'll pivot, and as they do so, they often forget about their patent applications. And so when you're investing in a company, it may turn out that their patent portfolio covers their previous product and doesn't actually provide any protection for their current product. And that's something you want to make sure they are doing as they go along. And finally, as I mentioned, there's freedom to operate. So what we've been talking about up to this point is companies protecting their own IP, but there's also the question of whether that company's products might infringe the IP of other third parties. And this is a really tricky issue because in some cases it's helpful to monitor the patents of key competitors, so you know whether they might have a patent that could block your product. But there are some risks. Under US patent law, if you are aware of a patent that you infringe, you are under an obligation to avoid infringement. And if you are aware of the patent and you proceed with selling your product knowing that it infringes, if you are eventually sued and lose at court, the damages against you can be tripled because you willfully infringed. So there is some risk in monitoring third-party patents. The US patent law creates a weird incentive to keep your head in the sand and not search for patents, which is you know, not very helpful for anyone. So freedom to operate is a really tricky thing. It's to do a search to see whether you have freedom to operate could be very, very expensive, many tens of thousands of dollars. And even then, you never really know. There are always patents issuing every month. And so if you do a search today, 1 month later, there will be new patents that you might infringe. So freedom to operate searches are expensive and limited in their effectiveness. So going back to your question, one of the sort of less expensive diligence tasks is to verify the ownership of the IP. You look for the recorded assignments. You also look to make sure that the company has put in place the proper contracts to protect the IP disclosed to their employees. There are some issues when it comes to standards organizations. Often membership in a standards organization will require there are some mandatory licensing obligations. So you just want to make sure that before you join a standards organization, you're careful about you're aware of what the obligations are. So again, when investing in early stage companies, you due diligence to just confirm that they are executing on some sort of IP strategy that's appropriate for their situation. And I think that's it. So we'll open it up to questions from the group.
Well, I'll start with one. If you're involved in a startup and someone infringes on your patent, what should you budget for the defense of your patent as a startup? Because usually startups are in cash crunch mode and they don't raise more than they need to. But if you're trying to defend a patent, I know that can be more difficult. So any advice on that?
So I'll defer to Pam. Pam has extensive experience litigating all sorts of IP disputes, and Pam would have a much better sense of this. Oh, I think you're muted still.
Thanks, Hugh. So the short answer is, it certainly costs a lot of money to litigate a patent dispute. And what I generally advise startups to do is to send an invitation to license letter instead of sending a cease and desist letter. If you send a cease and desist letter, you discover someone is infringing on your patent. You've given them the right to now sue you and bring an action in court under the Declaratory Judgment Act to ask the court to assess whether there is indeed patent infringement. So a carefully crafted letter places the third party on notice of your patent and, doesn't, if it's properly crafted, doesn't give rise to jurisdiction to bring suit. And it allows you and affords you some time, to raise capital, et cetera, while possible damages are accruing against the other side when you do indeed have time to initiate an action. But I really do counsel startups to avoid patent disputes because they're enormously expensive, as you've heard and can expect.
And if I've also heard about in litigation, you really want to shop for the right jurisdiction, that there are some that are not very favorable and some that are more favorable. Can you speak to that too?
Certainly. I mean, that's a highly specialized question. And I personally favor, it's automatically muting me, I'm sorry. Yes, it's a really specific inquiry on where you want to file suit and where you want to go. I prefer faster jurisdictions in Texas. Other people prefer other jurisdictions, Wisconsin, et cetera. And I would recommend, really consulting with your patent attorney, litigator, on the nature of your dispute and having them perform sort of an analysis of analogous disputes in various jurisdictions and outcomes. And they can provide all of that in a chart for you before they're even retained. So I would highly advise that. So you have a very clear history of what transpired in each particular jurisdiction.
I don't want to monopolize all the questions. Anybody else have one? Feel free to unmute yourself and ask it.
I guess there's one in the chat while we wait for other questions. There is, what should startups budget for the cost of getting a patent all the way through the process? And my answer is, most legal answers are, it depends. The bulk of the cost is typically, unfortunately, upfront. It's attorney's fees to prepare and file the patent application. And it really depends on the technology. If it's a very simple invention, the patent application is much cheaper to prepare. If it's very complex, it's much more expensive. It also depends on how much counseling you require. If you're very clear on what your invention is, it helps to focus the discussion. If you really need a lot of counseling as to what to protect, how to protect it, that drives costs up as well. A very rough budget is somewhere between $10,000 to $20,000 in attorney's fees to prepare and file the patent application. The patent office fees are the filing fees are, it varies depending on the size of the company, but it could be $800 or $1,600 for large entity clients. So that's the filing fee. After the patent application is filed, it typically goes in queue at the patent office and will sit there for 1 to 3 years. And there really isn't anything in the way of costs during that period. When it is finally examined, typically the patent office will issue something called an office action, where the patent examiner cites to some prior art and explains why the examiner believes that the invention is not patentable. At that point, you'll need to hire your patent attorney to prepare a response to that rejection. And that can cost somewhere between sort of $2,500 to $5,000, very roughly. If you're lucky, that'll be it. You'll convince the patent examiner that you're right, and the patent will proceed to issuance with a fairly minimal issue fee. It's $1,000 or so. If you're unlucky, you may have to continue fighting and going back and forth with the patent examiner. He'll issue more rejections. You'll have to file more responses, each round costing between $2,500 and $5,000 roughly.
Is there, given what you just said, is there a website or a form or something that can help a startup get all the information they need for the patents so that they don't have to take as much of your time to get it written?
Yeah, so the patent office has a number of resources available to, I think there's an independent inventor website, so that provides some guidance as to what patent applications require. There are various sources on the internet that describe what's required. There's a book from Nolo Press called Patent It Yourself, and I generally don't recommend that people try to patent things themselves. You are legally permitted to do it, but there are risks in going solo. But I found that book is actually fairly helpful in explaining to inventors the entire patent process, what's involved, what's required. So there's all of that, but I think the best approach is really to try to find a good patent attorney, talk to friends, try to get a referral to a reliable patent attorney, and they should be able to provide some guidance as to what could help drive that discussion. I have a sample invention disclosure form that has a series of questions that sort of help focus that discussion, and any good patent attorney should have the same.
And as Gary points out, K&L Gates, as an AOA sponsor, offers a fixed fee package for patents for startup companies. Of course, it depends upon the nature of the kind of patent you want to file, but you should feel free to reach out to K&L Gates for that if that's something of interest to you or one of your companies. Any other questions from the people on the call? I guess I'll ask one more then. We've heard in the popular press about the patent office being underfunded and understaffed, and that it's now taking much longer, and the patent examiners are not as experienced as they used to be. Is that something you see as well?
They have gotten much better in recent years. There was a period, maybe 10 or 15 years ago, where they were really seriously backlogged, but more recently they have taken sort of great steps in improving the process. The examiners are better trained. You know, they're actually funded by the filing fees, so they're self-funded, and for the most part, you know, they're largely good. Unfortunately, there are many examiners that are bad, that issue bad rejections, and it can be really problematic if your patent application lands with an examiner who doesn't know what they're doing. That said, there is an appeals process. So if you are stuck with a bad examiner, you can appeal, take your case to appeal, and it goes to a 3-judge panel, and they can help resolve any dispute you have with an unreasonable examiner. But that said, patent examiners do have broad discretion in what they determine is obvious or not obvious, and you're somewhat at the mercy of that.
Thank you. Any other questions? Give it a second. And I assume people are content with the content. It was very clear. I'd like to thank you, Pam, and the K&L Gates team for, first of all, putting on this hugely informative and very clear discussion of a topic that is generally not very clear to most investors and most startups. It was wonderful to see that your focus was really on action items that we can do to make things easier for us. But I'd also like to thank you for all your support that you've given through the years to the Alliance of Angels. And with that, I'd like to thank all the participants for being here for the hour. And again, thank you to Pam and you for the great job you did on this.
Thanks for having us.